right, everyone. Happy Monday. It's Monday. People always think Monday is a bad day, but it's a great day because it's a chance to begin anew. I know people may be a little bit off because of the change in time. If you don't like the change in time, write whomever you need to write to tell them to stop changing the time and that we are not bringing in crops. And if we are, that's what lights are for. So these are the rules of the 187 District Court. You are in a courtroom. What does that mean? That means that anything that you could not do if you were physically in the courtroom, you cannot do on this Zoom screen. So to people who are at your home, what that means is you're not allowed to be cooking breakfast, doing chores. You need to be dressed appropriately. That means no hats, no ball caps, none of that. If you're at work, you need to let your employer know that you are at work. And you need to let your employer, you need to let your employer know that you're in court, and you need to let them know that you need to take a break so that you can place your full attention on this court hearing. If you do not behave as though you're in court or behave professionally and you are at your home or at your work or online, what's going to end up happening is you are going to be required to appear in the 187 District Court in person. So what does that mean? That means that you're going to have to catch an Uber or a Lyft or the Via Bus. If you take the Via Bus still does not give change. And when you need exact change, you don't have it. So that bus ride is probably going to cost you $5 to $10. If you drive down, you're going to find there's a lot of construction, a lot of one-ways. And if you drive like I drive, there's a nail just waiting to get into your tire. And it doesn't matter if you are out of county, out of state, out of country, you're going to be required to appear in the 187 District Court if you do not follow the rules. The courtroom is located at 300 De La Rosa. It is on the 4th floor. If you are a defendant, your video needs to be shown at all times. There's only 2 exceptions to that rule. One, you have a phone call coming in. And if you have a phone call coming in, what's going to end up happening is your screen will go dark. You need to immediately decline that phone call because you're in a courtroom or you're signing paperwork. Any other reason your screen goes dark, you're going to be required to appear in person in the 187 District Court, no questions asked. To all of the people who are at the Bexar County Jail, you are not allowed to use the chat box. You're not allowed to use the internet. If you do any of these things, you're going to get sent back. I don't care. We're not doing this thing where you say, oh, I didn't know I couldn't use YouTube, or I'm sorry for using YouTube. Everyone here is an adult because this is an adult felony court. So you're not allowed to do those things. If you're at the jail and you're wearing a mask, you need to wear that mask. That mask needs to be put over your mouth and your nose. Don't think of yourself as doing it for you. You're doing it for people around you. I'm going to open the breakout rooms. When I open the breakout rooms, it's going to invite everyone to go to a breakout room. I repeat, do not go to a breakout room unless I specifically call you by name and assign you to a breakout room. To all the attorneys, if you have a plea bargain agreement, no matter how small you think that plea bargain agreement is, you will need to put that plea bargain agreement in the chat box to the court coordinator. She's going to be on Zoom shortly. She's going to be listed as Ferguson coordinator. She will need to know whether or not it's criminal trial division or family violence. She'll need to know if your plea is for probation or deferred adjudication or time. Do not text her, call her, chat her, email her, asking for a continuance. I'm the only person who can do that. Attorneys, when you go to a breakout room with your client, do not, I repeat, and I say this all the time, but I'm saying it again in all caps, do not tell your client that his hearing with this court is over. His hearing with this court is not over until I tell them it's over and I actually give them a reset. Do not, I repeat, do not leave your client in that breakout room by himself. Think of it this way. If you're having a party at your house and you invite me and I invite complete strangers that you don't know, I leave your home and you have to go get ice. Do you leave those people in your home to get ice, complete strangers? The answer to that is no. So think of those breakout rooms as your home. Don't leave complete strangers in there by themselves. Bring them back to the main room, especially the inmates. If you leave the inmate in the breakout room by themselves, the deputy is going to see them in that room by themselves and they're going to send them back to their cell. And as everyone knows, there's a shortage. So what's going to end up happening is going to be difficult, if near impossible, for us to get your client back. To all the inmates, if you behave inappropriately on this Zoom, you got to get sent back to your cell. And you all know about the staffing issues. We will see you in 60 to 90 days. No questions asked. To everyone, the name of your attorney will be called. Your name will not be called. If you don't hear your attorney's name, it's because your attorney is Zooming in another courtroom or had to appear in person in another courtroom. Please be patient. Your your attorney will Zoom in just as soon as they can. This is the order of the attorneys: Jay Norton, Bridget Guzman, Gary Chirac, Andrew Del Cuerto, Ed Cano, Keith Engelke, Louis Martinez, and Todd McCrae. Is there any attorney who's on the Zoom screen that I have missed? All right, attorneys, if you would add to your name the name of your client and whether or not it's criminal trial division or family violence, that would help us move things along quickly. If you don't know how to do that, just go to participants on your screen or participants on your phone. Once you go to participants on your screen or your phone, just tap your name and you will see a box drop down that says rename. Just add the name of your client and whether or not it's criminal trial division or family violence. Jay Norton.
Good morning, ma'am.
Good morning. Thanks for changing your name.
Well, now that I know how to do it.
Okay. I'm going to send you to breakout room number 3. Bridget Guzman.
Good morning, Judge. I was just being present for if Mr. Mamori had any questions.
Thank you so much. I got you mixed up with the attorney. Just give us a second.
No problem.
All right. Gary Chirac, is your client criminal trial division or family violence?
We've got an issue with this one. This guy was found incompetent last March. I don't think I've ever been noticed that he was found competent. We have never been in front of the magistrate on that issue. And additionally, I have a sanity notice of insanity, and he's never been evaluated for that.
Is he criminal trial division or family violence?
Family violence.
All right, I'm going to send you to breakout room number 1. Ms. Ferguson, if you'll go to breakout room number 1, please.
Thank you, ma'am.
Okay, I thought I saw Ryan Groomer. Oh, there he is. All right, Andrew Del Cuerto, Roland Ramos.
Good morning, Judge. It's Taylor from our office here.
All right, is it criminal trial division or family violence?
It's CTD, Judge.
All right, thank you for changing the name.
Yes.
I'm going to send you to number 4.
Thank you.
Ed Cano, I'm going to send you to number 5. Thank you for changing your name.
Yes, ma'am. Good morning, Judge.
Good morning. Keith Engelke, I'm going to send you to number 6. Thank you for changing your name. Louis Martinez, thank you for changing your name. I'll send you to 7.
Thank you, Judge.
All right, Todd McCrae, who do you have?
Good morning, Your Honor. I'm here on sentencing in the courtroom, in your courtroom with Mr. Pizzana. We're ready on sentencing, but there's a couple of things I'd like to do first. I'd like to be able to talk with Mr. Sanders, maybe via cell phone, because I can't go into a breakout room privately with him before sentencing. And I wanted to see if the court has received our sentencing memo.
All right, just one moment. Just one moment.
Yes, ma'am.
Yes, Mr. McRae, I received it.
Good, thank you. Could I take, before sentencing, could I take a minute to talk with Mr. Sanders via cell phone?
Yes.
I don't see him on the screen, and I've done some chatting with him, and he's not responding.
No, he's on the screen.
Oh, he is.
Yes.
Marcus, could you take my cell phone call before sentencing?
Yeah, of course.
Thank you.
Charles May, who do you have?
Good morning, Your Honor. I have Mr. Thomas Manning. I think it's a bond reduction here.
Criminal Trial Division or Family Violence?
Excuse me?
Criminal Trial Division or Family Violence?
Trial Division, Your Honor.
All right, I'll send you to breakout room number 8.
Thank you, Your Honor.
You're welcome.
Judge, I sent you a chat.
Mr. Chirac.
Yes, ma'am.
All right, Ms. Ferguson, Mr. Hernandez, I need a reset date and it needs to be referred to Judge Carruthers to see if maybe they can get a move on his bed.
Yes, ma'am. I spoke to them over there, Judge.
All right, so I need a reset date and it needs to be sent there.
Well, Judge, can we do a reset date before he's even found competent? He could be
It's
there.
a reset to go to Judge Carruthers so that Judge Carruthers can see maybe if he can get a bed for him soon.
I got you. I got you. It's Monday. My brain's not working yet.
That's okay. All right, we're going to set it for April 25th.
All right, Judge, can I be excused now?
Yes.
Thank you, ma'am.
And Ms. Ferguson, was Mr. Hernandez called to be in court today or no?
Yes, ma'am. But I'll go ahead and cancel that.
All right, thank you. All right, Ian Stewart,
Yes, ma'am.
how are you doing this morning?
I'm doing well. How are you doing, ma'am?
Oh, I'm doing great. It's a beautiful Monday. The sun's out. It's not too cold, not too hot. You're here for a compliance hearing, and there was a request to remove your device.
Yes, it is the Intoxilock device because I was ordered to get the Smart Start at home device.
Well, and I think that was because you were using alcohol, even though you were on the ignition interlock, you were using alcohol when you were at your home. That's why you're on both.
I had a problem with the Intoxilock device. The device doesn't even work when they tried to recalibrate it that last time on the issue that you're speaking about.
Well, now I have a positive UA, and you're telling them that it's due to hand sanitizer.
On the Smart Start or what?
It says that a violation occurred on March 1st at 10:07 p.m. and that you denied alcohol use, and you believe the violation was caused by hand sanitizer.
Yes.
All right, so here's the thing, Mr. Stewart. I would have warned you not to use hand sanitizer because people, do I believe that's what's causing the positive UA? No. But if that's what you say, I'm going to go along with that's what you're saying. But I'm not removing that device until you give me negative UAs on that intoxilizer. Do you understand? Or negative readings on the breathalyzer. Do you understand? So okay. Until that's done, it's not going to happen. I'm not removing it. Okay.
Yeah, and they'll see that all the other tests are passing. So.
All right. Once you give me, and whether or not it gets removed is completely in your hands. Once you show me that you're not drinking alcohol, then of course the court will reconsider. But for now, the removal is denied.
Okay, and I do have a question.
Yes.
Just to verify, because my probation officer, Officer Sandlin, she did tell me to only use the Smart Start device now because of the history with Intoxilock.
Well, what I can tell you is if you're driving, you're going to have to blow in that. That's what I'm going to tell you.
Okay, well, it's also the at-home device, so I just use the one, or do I use both?
Use both.
Okay.
All righty.
All right, and then that's it, or?
That's it. So if you bring me no high breath readings, then I'll consider removal. But until that happens, that's not going to happen. You understand?
Yes, ma'am.
And if you don't know before, I'll tell you again, don't use hand sanitizer.
Yes, ma'am.
All right. Do you have anything else? Is there any questions about anything else?
No, that's it.
All right. Rebecca, do you need to speak with him?
No, ma'am.
All right. Thank you, Mr. Stewart. And just one moment. All right, Mr. Gilbert Oliveras.
Yes, ma'am.
All right, how are you doing this morning?
I'm doing very good. Thank you for asking.
All right, let me see. All right, Mr. Olivares.
Yes, ma'am.
So on your case, you're waiting a treatment bed.
Yes, ma'am.
So you're number 19 on the list for the treatment.
19?
Number 19.
Wow. That's like six more months.
Go ahead. That's all it is.
Okay. Thank you for telling me that. I had no idea.
No, I like for people to know what's happening.
Yes, ma'am.
So what's going to end up happening is you're waiting for that treatment bed. I'm going to have you reset just so that we can make sure that we don't lose you.
Yes,
and that you know what's going on, okay?
Yes, ma'am.
So Ms. Ferguson, can you do a phantom date for Mr. Olivares, please? And I say phantom date, Mr. Olivares, because if I put a date in the system, then, and if you're up to go for a treatment bed, they won't accept you because they'll think that you have a pending hearing.
Oh, wow. Okay, that's good to know.
All right. So Ms. Ferguson, what date? So we're going to come back on April 18th to see where you are. And I'll note on the docket sheet that you're number 19.
Okay, that way I don't get bumped up higher.
Well, that way yes. That way if something happens, we'll know.
Okay.
All right, so we're going to bring you back on April 18th.
May I ask something? Sure. There was no way I could just take some NA classes out in the free?
No, the reason why is because the offense you're charged with, based upon that, this is the only option.
Okay, yes, ma'am.
All right. Otherwise, if there were other options available, I would use those options. The problem is there are not enough treatment beds available. People say, and I say people, you know, the powers that be say that they care about mental health treatment, but there are not enough beds. You know, yes.
I'm sorry, I do have one more question. I get off in September on probation. So what's going to happen? I know if you say I'm 19, I know that's at least 4 more months. And
well, not necessarily. I mean, you know, things can change, things can happen.
But what happens September when I'm supposed to get off probation and I'm still in jail?
Let's cross that bridge when we come to it.
Yes, ma'am.
All right, because we don't know until we know.
Yes, ma'am.
All right, do you have any other questions?
What was the date that you said I was supposed to come back and see you?
It's going to be April 18th.
April 18th, yes, ma'am.
All right, thank you, Mr. Olivares. Have a great rest of your day.
Yes, ma'am. I can leave?
Yes, number 14Q can go back.
Thank you.
Thank you. All right, Mr. Mamori.
Good morning, Judge. Judge, I'm here on 2 cases. I'm here on Virginia Ruiz. I had a motion to enter a bond on her MTR so she could bond out. And then I'm also here on Nicholas Courtney, Judge. I believe last time I checked, she was in medical.
Okay, so what's the first person, Bridget Ruiz, is that criminal trial division or family violence?
That is, I'm sorry, Judge, the motion to revoke is a criminal trial division.
All right, and then what is the name of your other client?
Nicholas Courtney.
Criminal trial division or family violence?
That is a criminal trial. It's assault security guard.
All right. I'm going to send you to breakout room number 7.
Thank you, Judge.
You're welcome. And everyone, just give me a moment while I sign paperwork. Catherine Valenzuela, who do you have?
I have Cheryl Martinez, CTD.
All right, I'm going to send you to breakout room number 3.
Okay.
All right, Jay Norton, what is happening with your case?
Judge, I've conferred with Michelle Martin, and we are lacking a number of, well, all the body-worn cameras. I think it's a tech thing. We're going to drop her off a thumb drive this week to try to complete all that.
Okay, and who's Michelle Martin?
That was my maiden name.
I'm sorry.
Okay.
I'm calling her Michelle. Sorry about that, Michelle. Old habits.
Okay.
Yeah, it's Michelle Martin's just some lady I met on the street that I thought I'd talk about the case with.
All right. So, Ms. Hayden, when do you think you will have this information, or do you already have it? It's just not
Judge, we already have almost everything. May need to follow up on some CPS records, but we do have some CPS records, and then we've got the body-worn camera, and it's just on a flash drive, but the players, they have specific players for the videos. So it's I mean, it might be possible to upload.
I think I froze, or somebody froze.
But it seemed like the safest bet is just to copy for defense everything that we have. But I can take care of that as soon as they bring me in a thumb drive.
And what's the status of the CPS records?
Well, we have a few pages, but they're pretty limited. So we may need to request additional records.
Okay. Ms. Ferguson, can I have a discovery reset date on Mr. Boyd, please? All right, we're going to come back on April 18th.
April 18th.
Yes, if there's nothing else, you and your client are excused.
That's all for Mr. Boyd. I also have Eric Flores with CTD. I've been speaking with Brittany Sparks on that one previously.
All right. Have you conferred with her on that yet?
Not today, ma'am.
Okay. All right, I'm going to send you to breakout room number 4.
Okay, thank you.
Let me see if I can find you. There you are. Matthew Allen, who do you have?
Nicholas Cornelius.
Criminal Trial Division or Family Violence?
I believe it's Criminal Trial Division.
I'm going to send you to number 9.
Thank you, Judge.
You're welcome. James Otersdorf, who do you have?
I have Jasmine, Colorado. She is in custody. We were here on the 23rd of February, but I can't find the name of the prosecutor. The prosecutor at that time wanted to find out a little more about the victims in the cases before.
All right, is it Criminal Trial Division or Family Violence?
Judge, I believe it's going to be family violence because of the relationships, but I'm not sure. There's it's hard to tell. I think that's what they were trying to determine, quite honestly.
All right, I'm going to send you to breakout room number 10.
I'm surprised somebody hasn't jumped up and said, that's my case. Thank you.
You're welcome. Taylor Wood.
Yes, Judge. I conferred with Joe Ray, and we're still waiting on some discovery on our case.
What discovery?
The crash data retrieval. It was an intox assault. There's an accident, and there's a download from one of the vehicles that we don't have.
And have they told you when that they are expecting that?
They sent the request while I was conferring with them. So I would assume it would be within the month.
Excuse me. Joe Ray, on Mr. Landon, do you know when that discovery will be ready?
Judge, we're just asking 2 weeks. We had a lot of discovery come in. We have all the videos, EMS, medical records. We have the supplement report for the CDR, but defense is asking for the actual data from the software. And that's all that I need to request from the detective. It's just one more thing. It should only take 2 weeks.
All right, Ms. Ferguson, on Carlos Landon, if I can have a 30-day reset for discovery, and that should give you all more than enough time, Mr. Garcia.
Yes, Judge.
All right, so we're going to come back on April 18th, and specifically, I'm sorry, Mr. Garcia, what information needs to be given to the defense?
So it's Bosch data software for the CDR, the crash report.
Okay. All right, if there's nothing else, then Ms. Wood, you and your client are excused.
Thank you, Judge.
You're welcome. Thank you for coming into the main room, Joe Ray.
You're welcome. Thanks, Judge.
May I approach, Judge?
Yes.
I'm back from conferring. My client has a bird hab, and in addition to the theft, which I represent him, and the state has told me they want to take care of the bird hab first.
Okay, Brenda, you're a great court reporter. Can you understand what he said?
They want to take care of the bird hab first.
All right. And are you the attorney on the burglary of the habitation?
No, I'm not. Natasha Torres is.
Natasha Torres.
All right, thank you. I don't know, it always sounds like you're underwater.
I'm trying different variations.
That and my allergy ear just doesn't make for a good combination. Ms. Ferguson, can you see if Natasha Torres is available to Zoom in, please?
I send her the invite, Judge. Let me find out where she's at. Okay.
Just give us a moment, Mr. Engelkey.
Yes, ma'am.
All right, Mr. Mamori.
Morning, Judge. I've conferred with AJ Brittany Sparks on Nicholas Courtney, Judge. Is Nicholas Courtney here? Yeah, I see. Yeah, Nicholas there. So I need to confer with my client, Judge. Before that, on Virginia Ruiz, Judge, I filed a application for writ seeking bail on this, Judge, and we had an agreed order with Ryan Groomer, and that was e-filed and accepted on March 9th, at 10:02, and I had CC'd the court on it. I'd like to see if it's possible that we can get her a bond on this and get her out so I can confer with her when she's not in custody, Judge.
That has already been signed. When is she? That order has already been signed.
It was, what was the bond amount? I didn't get a copy of that, Judge.
It was whatever amount you all agreed upon.
Okay, so
that's the amount that the court set it at.
Okay. How would I get a copy of that signed order, Judge, please?
All right. To the clerks, could you send us a copy of the signed order to Mr. Mamori, please?
Yes, Judge.
On Virginia Ruiz.
Yes.
Judge, and then if I can confer with my client, Nicholas Courtney.
All right,
please.
Just one moment.
Thank you, Judge.
Judge, and I sent you a chat.
Okay. So on Miss Virginia Ruiz, is there something else you needed from probation? My understanding there was some issue with some discovery.
It had to do with the court summary, Judge. There is some disagreement with probation and court admin that the court summary somehow is subject to the court's unilateral authority on whether it's released to defense attorney, Judge. And that is something that I'm going back and forth with them. And they have shown me no authority that says that the court has unilateral authority to either release or withhold the court summary on a motion to revoke. They've cited to judicial rule, I think 12, but that only applies to let me pull that up. That only applies to when a request is made under the Public Information Act. It does not specify that a adult probation MTR or court summary is not to be released automatically to defense counsel, Judge. And this court knows very well that defense counsel is unable to properly and fully represent a client unless we have the court summary, Judge. That would be, we could get sandbagged around the corner on a motion to revoke.
All right. So I'm sure as attorneys are aware, if you were in person in a courtroom you can look at the probation's file all you want, review it, look through it. But because everything is on Zoom, there is no looking at file. There are people who wanting copies of files. I try to make discovery as easy as possible in this case. And so attorneys, the only thing you have to do is file a motion. The court will file the motion. The probation will give you the documents for you to review. And they'll give you the documents, I'm sure, with a protective order in it as well, because some of the things that are in their files are protected matters. So that's where we are. So if anyone has an issue without receiving something from probation, just file a motion.
Well, Judge, that's precisely the point. I don't think we need to file a motion. We should be automatically getting that information. There's no authority that they've cited that says that they can withhold that subject to a motion.
Some of the information that's in their file is protected information. For example, if you have a client who's on deferred adjudication, I'm not saying this applies to your client, but if you have your client who's on deferred adjudication for a sex offense, there are things in there that are protected and they just don't want them flowing around. As a matter of fact, when people come on Zoom wanting to say that somebody has COVID, I'm like, I guess people are not following HIPAA anymore. So there are certain things that are in the file that are confidential. I think probation, and this is not me speaking from probation, this is just me looking at things globally as experience as a former defense attorney and a former prosecutor. I don't think that probation wants to be liable civilly for releasing something that's confidential. So to make it easy, if people would just file a motion, guess what? You're going to end up getting it. But if you file a motion, and if I order probation to give it to you, then guess what? They're not on the hook they're not on the hook civilly or any type of other way. They're like, hey, I'm doing this because the judge said. It's the same thing with CPS records. That's why they do protective orders. They come to me. People know in this court that I think defense attorneys should have CPS records so they can review them, go over them with their clients. But guess what? The state just can't say, oh, well, you're entitled to these CPS records. I know people believe, that there are magical words to receiving documents, but sometimes you have to go through the steps so that everybody is protected and they're not liable for anything that they may release. So on Ruiz, do you have all the documents that you wanted, Mr. Mamori?
On Virginia Ruiz, I don't know at this point, Judge. I need to get her bonded out and review everything with her before I make any representations to the court.
Okay. So Ms. Ferguson, on Ms. Virginia Ruiz, can we have a 30-day reset for a contested hearing? And if it turns out if it's not contested, Mr. Mamori, just let the court know.
Sure.
All right. And the probation is here, Ms. Guzman, if you need to speak with her about any other documents.
Not at this time, Judge.
Okay.
So when do we have a date on the MTR?
Yes, it's going to be April 13th at 2 p.m. And that will be for a contested. And if it's not going to be a contested, just let Ms. Ferguson know and she'll move it to in the morning.
And that's April 13th?
Yes, April 13th. Do you need to speak with Ms. Ruiz? I don't see her on the Zoom.
No, I don't know if is she here or did she, when did the court sign that order?
The same day it was sent.
Then she should have, I don't know if she's bonded out yet. I haven't checked. I didn't even know the order had been signed. So let me look at that. And then once I get that, and then if I can confer with Nicholas Courtney, Judge, please.
Okay, I'm going to rename you to remove Ruiz. And you don't need to speak with Ms. Guzman, correct?
No, Judge.
All right.
Thank you very much.
All right, sure. All right, if you'll go back to your original breakout room, Mr. Mamori, which was 7, and Ms. Guzman, you are excused.
Thank you, Judge.
You're welcome. All right, everyone, just give me a moment. All right, Keith Engelkey. We're still waiting for Miss Natasha Torres to come in. As soon as she comes in, we'll have her go into the breakout room.
Your Honor.
All right, John Foley, you have Briones. And that's family violence, correct? He's on mute. I'm going to send you to number 11.
Sorry, Judge, I was holding down my space bar, but it wasn't doing anything. Yes, I have Briones. That is family violence.
Okay. All right, I'm going to send you to number 11.
Thank you.
Your Honor.
Just a moment.
Okay.
Miss Virginia Ruiz, I'm going to send you to a breakout room with your attorney, Mr. Mamori. He's in 7. Your court, your date has been reset for April 13th for a contested hearing, but I'll let you speak to your attorney about that.
Thank you, Your Honor.
You're welcome. Matthew Allen.
Yes, Your Honor. I conferred. I don't see Mr. Cornelius on the Zoom, though.
Is he in custody or on bond?
He is on bond. This is a different attorney was on the case. I was just recently appointed, so I'm still reviewing the discovery, but I did get a chance to confer with Mr. Sanders on it.
All right. All right, what I'm going to do, I'm going to recall this, Mr. Allen, so that you'll have time to get in your contact with your client and make sure he appears for court. Although what I can tell you is I did give him this, this new date. Ms. Ferguson, can we recall this for March 31st? All right, so we're going to come back on March 31st. I'm going to note that your client wasn't present, so if you can't get in touch with him by that time, a warrant may be issued.
Okay, thank you, Judge.
You're welcome. Is there any discovery that you think you need or that's outstanding?
I don't think so.
Okay, then. All right, you are excused.
Thank you, Judge.
You're welcome. All right, Mr. Let's see. Mr. Engelkey?
Yes. I also have a case with Cheryl Martinez.
All right. Is it criminal trial division or family violence?
It is, and there's another attorney here, I believe, that is on the same on several other cases with Cheryl Martinez. I believe that was Catherine Valenzuela.
Judge, the other attorney is waiting for him in breakout room 3.
All right, I'll send you to number 3.
Yes, thank you.
All right, Charles May.
I'm sorry, Your Honor.
That's okay. What is happening with Mr. Manning?
Judge, I was with Mr. Sanders, and he's opposed to any that type of bond reduction. So we're requesting a hearing on bond reduction, Your Honor.
Okay, just give me a moment and we'll take that up. Mr. Jay Norton on Mr. Flores.
Yes, excuse me. Yes, Your Honor.
Yes, what is happening with this case?
I think we are presently at an impasse, so I guess the appropriate thing would be to set it for trial at this point.
All right, so what I have today is the state was to review evidence provided by the defense. Have you reviewed that? Who's the state you were conferring with?
Ms. Sparks.
Yes, Judge, we've been able to review the things that were sent to us from defense counsel.
All right, has an offer been tendered?
Actually, I don't believe so.
All right, State, are you prepared to make an offer?
Yes, Judge.
All right, so Mr. Norton, if you'll go back to, let me see. If you go back to breakout room number 4, they'll make an offer and then I'll give you your dates.
Okay, thank you, Judge.
All right, Mr. May, on Mr. Manning. Marcus Sanders, are you ready to proceed on Manning? Charles May? All right. Nathan Slemaine, I'm going to send you to breakout room number 7.
Thank you, Your Honor.
Charles Blanc, who do you have?
Yes, Judge, I'm present.
Yes, who do you have?
James Pareda. I'm sorry, I forgot to rename myself.
That's okay. Is it criminal trial division or family violence?
I believe it to be criminal trial division.
All right. I'm sorry, what? I'm going to send you to number 9.
Thank you.
You're welcome. Charles May, going once.
Should I text?
I'm sorry, Your Honor.
That's okay. Are you ready to proceed, Mr. May?
Yes, Your Honor.
All right. Before we go on to record, State, are you ready to proceed on this motion for a bond reduction?
I am now, Judge.
All right. The court is going to call 2021 CR 11393, State of Texas versus Thomas Manning. Could I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Charles Mays for the defense, Your Honor.
And are you Mr. Manning?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No objections, Your Honor.
Mr. Manning, do you have any objections to this hearing taking place by video?
No, ma'am.
The defense has filed a motion seeking bond reduction. State, have you ever had a chance to review the defense's motion?
Yes, Judge.
Are you ready to proceed, State?
Yes, Your Honor.
All right, defense, it's your motion. You may begin.
Thank you, Your Honor. Your Honor, at this time, we would ask the court to take into consideration this is a serious offense. We're not denying that, Judge. But also, there's a $75,000 bond on this offense, Judge, which is aggravated assault with a deadly weapon. And Judge, we're asking that the court reduce the bond. Mr. Manning has been incarcerated for some time now. I think it's been over 3 months, if I'm correct, Your Honor. And,
It's been 6 months.
Okay. Thank
Excuse
you.
me, Mr. Manning. The way it operates here is that one person speaks at a time. No one interrupts anyone. If your attorney wants to call you as a witness, he will have you sworn in and then he can ask questions of you. All right, Mr. May.
Thank you, Your Honor. Yeah, at this time, Your Honor, I would call Mr. Thomas Manning, please.
All right, Mr. Manning, can you raise your hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand. Defense?
Thank you, Your Honor. Thomas, how long have you been in jail?
I have been in jail approximately 6 months now. I think about 10 days short of 6 months.
Okay. And do you have any type of savings accounts?
No, sir, I do not. I do not have any savings accounts. I do have a young child that I need to get back to who is developmentally being withheld because of the COVID. She has a problem reading. She's almost 8 years old and cannot read. Her mother is a nurse and is working a lot due to the pandemic.
Okay. Let me stop you there, Mr. Mann. Okay, you have one child, is that correct?
Yes, I have one child under the age of 18.
Okay, and she does have some mental health problems that need to be taken care of, is that correct?
I would not call mental health, but I would say developmentally as far as her education due to her schooling being broken up constantly because of the pandemic.
Okay, no, my mistake. Now, Mr. Manning, do you have any type of property or land that you can sell or any to get any funds to make this bond?
No, sir. Currently, I do not own any property, any vehicles. I do not have any money in any bank accounts. It would be a struggle to come up with a bond at $75,000.
Now, Mr. Manning, what amount of bond do you think would be reasonable that you could afford?
Through borrowing from friends and family, I believe that 15 to 20,000 would be reasonable.
15 to 20,000. Okay. And again, if the judge does decide to lower your bond, do you have any type of employment, or once you're released, will you be able to get any type of employment?
I have had several offers from friends of mine who own several businesses. I will be on a monitor device, as I've been told before, for if I am bonded out, and I will try to find work that will go along with what times they allow me to be out on the monitor.
Okay. So you are asking this court to allow you to go to work, in other words, kind of like a partial house arrest? Is that a first statement?
Yes, work would be the only reason that I would leave the house.
Okay. Well, I'll pass a witness, Your Honor.
State.
Mr. Manning, have you ever been diagnosed with any mental health illnesses or conditions?
As the judge quoted earlier, I'm not sure I have to answer that because of HEPA, but yes, I have.
Okay, and what conditions?
Once again, due to HEPA, I do not have to release that in the court. I mean, if you have it, you would have it on file, correct?
Mr. Manning, have you been diagnosed as a bipolar schizophrenic before?
Bipolar, yes. Schizophrenic, no.
Are there any other mental health conditions that I've missed?
No, sir, and I am currently medicated for the bipolar.
Who are you medicated through?
Right now, I am medicated through Bexar County. I do have prescriptions awaiting me as I release from Bexar County.
Okay, and prior to being at the Bexar County Jail, were you taking medication?
I was off and on my medication. We had tried different ones. I'm not sure if you're aware, but as far as mental health, with a lot of the medications, it takes 30 days for them to become active in your system. And it's kind of a trial and error to see which ones work with your own chemical makeup.
Okay, pass the witness, Judge.
Right, defense.
Nothing further, Your Honor. We would just ask this court to set a reasonable bond. As he heard the evidence judge, Mr. Manning can afford anywhere between $15,000 to $20,000, and we would ask this court to set a bond within that range, Your Honor. Also with the conditions of a partial house arrest, subject just permission to go to work, go back to and from work, Your Honor.
All right, state any evidence or witnesses.
No witnesses, Judge. We do have evidence. State is offering State's Exhibit 1, which has been emailed to the judge, the court reporter, and defense.
No objections, Your Honor.
All right, then State's Exhibit number 1 is admitted into evidence. Everyone just give me a moment to review it. All right, the court has reviewed State's Exhibit number 1. The court will hear argument. Defense.
Again, Your Honor, we would ask this court to set a reasonable amount of bond in the range of $15,000 to $20,000. I think there's been evidence to show that Mr. Manning can afford that type of bond. I think $75,000 is way excessive, Judge. And also, Judge, we would ask that if you set the bond, whenever he makes bond, that conditions of partial house arrest where he's under house arrest, but is released to go to and from work. And pretty much that's about it, Your Honor.
All right, State.
Judge, as you can see in the State's Exhibit 1, the facts of the case are very concerning. And so we are strongly opposed to any reduction in his bond. It's alleged that he came from behind to one of the witnesses and tried to cut his throat. He ends up stabbing both of the alleged victims multiple times. And one of the witnesses, who was, I believe, a previous girlfriend, she stated that he had schizophrenia and bipolar disorder. And so it's concerning to think that he would be out, possibly get off of his medications, and something like this could happen again. I also spoke to defense about filing a motion to have him evaluated because I think that that's necessary for this case to proceed. So we are opposed to any reduction in his bond.
All right, defense, it's your motion, so I'll give you a final argument.
Judge, again, Judge, we would just ask the court to take into consideration the amount of bond that's that is right now, and the amount of bond that my client can afford, which is a $15,000 to $20,000. And I believe that the house arrest, partial house arrest, and him going to and from work, if need, I can file a motion for some psychiatric evaluation, Judge. And but we would ask this court to go ahead and reduce Mr. Manning's bond at this time, Judge.
All right, motion for reduction will be denied. The court will order full GPS if he's released, waive fees, and there should be no unsupervised contact with minors. Where are we on evidence being received on this case, Mr. May?
Judge, I believe I'll have the majority of the evidence. And as the state said, Your Honor, probably what I'm going to do is go ahead and file my motion for psychiatric evaluation and possibly insanity at the same time, Your Honor.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Manning, please? And are you going to file that motion, or are you requesting the court to do a referral for evaluation?
Judge, if it's okay with the court, I would ask the court to go ahead and do the referral, Judge.
All right, Ms. Ferguson, I'm going to need a referral for a psychological evaluation for Mr. Manning, please, and a 30-day reset. All right, we're going to come back on April 26th. All right, if there's nothing else, do you need to speak with Mr. Manning, Mr. May?
Yes, if you don't mind, Judge, I would like to visit.
All right, if you'll make sure that he comes back to the main room, please.
Okay, thank you, Judge.
I'm going to send you to breakout room number 9.
Okay, thank you.
And Mr. Manning, I'll send you to number 9. John Foley?
Yes, Your Honor.
If you could show your video, please.
Yes, Your Honor.
What is happening with Ms. Briones?
Judge, we are ready. I was just this second texting Ms. Hayden to ask her if we spoke, but then I forgot to ask her if she has a discovery compliance ready for me to sign, and we're prepared to sign that today. And that's where we're at, I guess. The only issue I have with trial is we have an out-of-state expert that I'll need to give notice to as far as, as far as timing.
All right, I'm going to send you all to breakout room number 1. And Ms. Ferguson, if you can go to number 1 to confer over a trial date with Ms. Hayden and Mr. Falling. I don't do special trial settings because things end up happening, but I'm going to send you to breakout room number 1. Ms. Ferguson will go there and speak to you about your trial date.
Thank you, Judge.
And then we'll put it on the record. All right, who's the prosecutor on Pisani?
Judge, that's Marcus.
Okay.
Mr. Sanders, Your Honor. Yeah, Judge, we have a preliminary matter.
Yes.
Judge, there's been, I guess, a change in our plea agreement, and we want to let the court know that we are no longer opposed to his application, and so we'll put it on the record. And
okay. All right. The court is, I think he only pled to 1 case. Is that correct?
Correct, Your Honor.
All right. The court is calling 2021 CR 7439, State of Texas versus Victor Pisani. Could I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Todd McCrae for Victor Pisani, Your Honor.
And are you Mr. Pisani?
Yes, ma'am, I am.
We're proceeding by video, but the court will note for the record that the defendant and defense counsel are in the courtroom, but we're proceeding by video due to the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Pisani, do you have any objection to us appearing by video?
Not at all, no, ma'am.
All right. So we're here for sentencing. According to the plea bargain agreement, the state was opposed to the defense's application for probation or deferred adjudication. Off the record, the court has been made aware that the defense wishes to change the plea agreement. Is that correct, defense and state?
Yes, Your Honor.
Yes, Judge.
And what are you changing the plea agreement to?
Judge, the state is withdrawing its opposition to his application for deferred. Additionally, we've agreed to recommend to the court that he be placed on deferred for 10 years. We don't have an agreement on another condition, and that's what we'd like to discuss with the court. The state is asking that he be placed in inpatient status based on the TAP evaluation, but defense is asking for something else.
All right. So what I need both parties to do, because as you know, contracts are contracts, and this plea bargain agreement is a contract. So the only thing I need state and defense to do, this page, the plea bargain page, that single page, I need you all to redo it and put it as an amendment or an addendum to the previous plea bargain agreement so that that can be done properly and follow the rules of contracts. So if y'all will just redo that page.
Judge, I don't think I'll be able to add a minute to the top. I can redo the page, and Todd, if you can, I guess when you get it and it gets printed out, if you can just write amended plea bargain, if that's okay with the court.
Yes.
I could go back to the clerk's office and write amended at the top. Is that what you would suggest?
Yes.
Okay.
So, but you all will be receiving the paperwork through Deputy Laura's computer.
Okay.
And then you'll sign off on it and your client will sign off on it. And then I'll take up your sentencing.
And that paperwork will be coming from who?
Marcus.
Okay, Marcus.
Yes.
Yes, ma'am.
And the only thing that's coming your way is an amendment to your plea bargain agreement, since now the state is saying they're recommending deferred adjudication.
And we'll sign it as soon as it arrives here in court.
All right, thank you. And we are off the record. All right, Mr. May, did you finish speaking with Mr. Manning?
Yes, Your Honor, I have.
All right, thank you. Then you're excused.
Thank you, Your Honor.
Am I excused as well?
No, just remain there. We'll have to have someone remove you just a second. To the clerk, could you let the jail know that Mr. Manning can go back, please?
Yes, Judge.
All right, Mr. Cano.
Hey, Judge. Judge, I've conferred with counsel. My client has a new injury to a child case that he was indicted on January 26th. And so we have just recently downloaded quite a bit of information, includes at least 21 videos. Judge, there's some CPS records. There's co-defendants, and there's CPS records that we don't have access to because we're requesting. I filed a motion and a proposed order to try to get court permission to get those CPS records that have to do with this charge.
All right, who's the prosecutor you were conferring with?
Is it Mr.
Michael, Judge.
Michael.
The state will make sure that you have access to the CPS records. State, where are you on the discovery in both of these cases?
As long as you sign the order for the CPS records, we can turn those over and have a disc ready for him to pick up. And we'll file the normal paper for the protective order. As far as discovery is concerned, we have everything other than in reviewing his criminal history. There's some potentially prior other judgments that we need to pull, but I imagine that should be quick. But now that I said it on the record, I'm sure it won't be quick.
No, Brendan didn't take it, so it's not on the record.
So I hopefully will be quick. I'll request them today, and hopefully they'll be in as soon as again. We'll scan a copy, be available on discovery.
Okay.
Yes,
so just one moment. All right, so we're going to come back on April 26th for discovery.
Okay.
Thank you, Judge.
All right. Oh, and let me ask you, State, who are the co-defendants?
Kayla White, Kayla Connor, and the last one's escaping me right now.
All right, are these listed as co-defendants?
I believe that they are, that they're A, B, C, D.
All right, I'll talk to Ms. Ferguson about placing these on the same date.
Thank you, Judge.
Judge, I have a Christopher White, a Kayla Connor, and a Kayla White. Okay. So 2 Kaylas, yeah.
All right, thank you.
Yes, Judge. Judge, can I be excused?
Yes, you can be excused.
Now, Your Honor, am I going to get, I have a proposed order to get those CPS records, but I understand that you've ordered those from the bench, so I'm understanding that Mr. Viettia will make those available to me now.
No, what will end up happening, they'll send a release form for me to approve, and then you'll be able to obtain the CPS records at that time.
Yes, ma'am.
Thank you. All right, Norma, I'm sorry, Lupe, can you let them know that Mr. White, L16 can go back?
Yes, Judge.
Charles Bach? Nicholas Cornelius?
Yes, ma'am.
You need to show your video. Mr. Cornelius, every time you come on Zoom, I have to tell you to show your video. This is the last time, and I'm notating in your file, this is the last time I'm going to do that. After that point, your Zoom privileges are going to be revoked permanently. Do you understand?
Yes, ma'am.
And you need to make sure you're on time for court. You're late. Your court was at 9 a.m. Your next court date is going to be on March 31st at 9 a.m. You need to be on time. If you're not here at 9 a.m., there's going to be an issue. Do you understand?
Yes, ma'am.
All right. See you on March 31st. Charles Bach.
Yes, Judge, I'm present.
Hi, where is your client?
That's a great question. I believe he's in jail. Let me check. Hold on 1 second. I'll check.
Okay. And Brenna, I think I'm going to have to go into breakout room number 1. It's taking forever to get a date for a jury trial. So I will be right back and solve this issue.
Judge, I've learned Mr. Pareda is in jail.
All right, Jess, give us a moment.
Okay, thank you.
All right, Ms. Fergus, can you give me an ETA on Charles Bunk's client, please? All right, the court is going to call 2018 CR 9355 and 2021 CR 8893, State of Texas versus Jessica Briones. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
John Foley, Your Honor, for the defense.
Okay. And are you Ms. Briones?
Yes, I am, Your Honor.
All right, I'm going to need you to speak up, Ms. Briones, so that the court reporter can hear.
Yes, Your Honor.
All right, and the court called out 2 cause numbers. The 2018 CR 9355 was re-indicted, and that new case number for that case is 2021 CR 8893. This case appears to have been pending, at least I see entries, since September 2018 for this case. Defense, have you received all the discovery in this case?
We have, Your Honor.
State, has an offer been tendered?
Yes, Your Honor.
Ms. Briones, are you rejecting that offer?
Yes, as far as I understand it.
Are you requesting a jury trial?
Yes, Your Honor.
Your jury trial date will be March 31st at 9 a.m. You need to appear in person in the 187 District Court at 9 a.m. on May 31st. Did I say June, Brenna? Yeah.
It's March.
March. I'm like, everybody was in a state of shock. But your jury trial date will be May 31st at 9 a.m. You'll need to appear dressed for trial in the 187 District Court on May 31st at 9 a.m. Courtroom is located on the 4th floor at 300 De La Rosa. Do you understand?
Yes, Your Honor.
All right. When is your jury trial date?
May 31st at 9 a.m.
And which court?
The 187.
And where's the courtroom located?
300 Dolorosa Street.
That is correct. Brenna, I don't know why. You know, the ladies always get that correct. All right. If there's nothing else, we'll close the record. And Ms. Briones, that will be all. Have a great rest of your day.
Thank you.
Thank you, Your Honor. May we be excused?
Yes. And everyone, just give me a moment to sign some paperwork. All right. On Flores?
Yes, Your Honor.
Yes, what is happening with Flores?
We have received a plea offer that I would like to go over in person with Mr. Flores. It is a to-do offer, but I think it's one that I would like to discuss with him. If I could have a reset to do that, Your Honor, in person.
Okay. All right. All right, Ms. Ferguson. Mr. Flores, can I have a 2-week reset, please? All right, we're going to come back on April 11th. That's your plea deadline date.
Yes, ma'am.
All right, you and your client are excused.
May I go into a breakout room with Mr. Flores briefly?
Yes, and you all can be excused from the breakout room.
Thank you, Judge.
You're welcome. Mr. Flores, let me see. Mr. Norton, if you'll go back to breakout room number 4, and Mr. Flores, if you'll go to 4, please.
Yes, ma'am. Have a good day.
Yeah. Thank you, you too. Jeannie Bloomster, who do you have? You're on mute.
Sorry, I was trying to do a chat. I have Rosalind Bagley.
Where are we going to go? Is it criminal trial division or family violence?
Criminal trials, MNTR.
All right, I'll send you to breakout room number 5.
Thank you.
You're welcome.
I don't want to do it here.
Catherine Valenzuela.
Your Honor, we're still conferring. I came out here to chat. Joe Ray, I'm going to go back to the breakout room.
All right. Nathan Slimane.
Your Honor, if the court has received all the paperwork on Mr. Torres, I believe he's ready to be sworn, and then we can proceed.
All right, let me see if any paperwork has been sent to me. All right, I haven't received any paperwork other than the consent. So is this a new case?
No, this is on the robbery.
Is it a plea on a new case, or is it a motion to revoke? Because I only have a consent to plea for.
It's a plea on a new case. Let me go back. The deputy had indicated that everything's been signed and sent.
All right, I'll send you both to breakout room number 4.
Okay, thank you, Judge.
Well, you know what? Actually, I'm going to send you to 1, and the clerk will meet you in breakout room number 1 because the court does not have those paperwork.
Okay, thank you, Judge.
Thank you, Judge.
Ms. Ferguson on Brandon White. There are 3 co-defendants. If you can place them all on April 26th, please.
You know, I don't know.
Ma'am, where do I go?
You stay where you are until you're requested to go
Just
to a
me and
breakout
her.
room.
Okay.
And Ms. Ferguson, I placed something in the chat box for you. James Oltersdorf, who are you here for?
I have to keep coming and going. Jasmine, Colorado, and I think I was talking to Marcus the last time on the 23rd of February. I remember it now. He was going to look up some things to see where we were on the plea.
I'll send you to number 2.
Thank you.
Question, Your Honor.
Who's asking a question?
Can I go to the breakout room with my attorney, or he has to request it?
He needs to request it.
Thank you.
You're welcome. Yes, Catherine Valenzuela.
Yes, Your Honor, we will be taking a plea on Cheryl Martinez. I'm chatting Ms. Ferguson the cause numbers on the cases we will be pleading on.
All right, thank you. Yes, Ms. Bloomster. You're on mute.
Yeah, sorry. Okay, I confer with the state and probation, and we need till April 7th for them to do a MIC evaluation on her and a TAP evaluation. These things were never done when she got out. She never showed up for them.
All right, Ms. Ferguson, can I have a reset date on Ms. Bagley, please? And did they give you an ETA on how long they think that will take?
Well, they said 3 weeks, so we should ask for April 7th. I don't know if they were looking at your calendar or what, but they said April 7th.
All right, Ms. Ferguson, is April 7th, okay? All right, so we're going to come back on April 7th.
Can I have a bond? Can I have a bond?
No, you're remanded without bond.
That's why I asked for one.
You've asked for it and I'm remanding you without bond.
Thank you.
You didn't show up for anything according to everyone. Well,
and they said,
here's the thing. No.
It was y'all's fault. It was y'all's fault.
Nope. Here's the thing. I allowed you out on bond, and I allowed you out on bond, out of custody for your MIC evaluation, and you didn't show up for it. So now you're going to do your MIC evaluation. You're going to do your TAP evaluation while you're in custody. It's a Class A, it's a Class B misdemeanor. If you decide that you don't want to be on probation, just let your attorney know and we can hear your motion to revoke now. It's completely up to you. I'm going to send you to a breakout room with your attorney, but your next court date is April 7th. So Ms. Bloomster, if you go to breakout room number 4 and Ms. Bagley will meet you in 4.
Yes, ma'am. Thank you.
You're welcome.
And Judge, I'm going to join them so that way I could start the referral process.
All right. Thank you. Do you have the plea paperwork on Pisana? Thank you. Mm-hmm. All right, are the prosecutor and defense ready on Mr. Pisana?
I'm present with Mr. Pisana in the courtroom, Your Honor. And you should have our new plea bargain agreement in writing.
Yes, I do. Marcus Sanders.
I'm back, Judge.
Okay. All right. We are back on the record in 2021 CR 7439, State of Texas versus Victor Pisana. Could I have parties re-announce for the record, please, for the state?
Marcus Sanders.
For the defense?
Todd McCrae for Victor Pisana, Your Honor.
All right. This is for sentencing. There was a previous plea bargain agreement that was entered. The defense and the state have filed an amended plea bargain agreement. According to that amended agreement, the state is proceeding on count 1. They're asking for a $1,500 fine, recommending deferred adjudication. They will take in consideration 2021 CR 7441 and 2021 CR 7440. Mr. Pisana, did you have a chance to review the amended plea bargain agreement?
I did, Your Honor.
Did you review it with your attorney? Did you understand it?
Yes, Your Honor.
Did you understand that to be the new plea bargain agreement?
I do, Your Honor.
Are you asking the court to follow that new plea bargain agreement?
I'm sincerely asking the court to follow it, please.
Defense, is that the plea bargain agreement?
Yes, it is, Your Honor.
And defense, have you been able to confer with your client over the changes from the original plea bargain agreement into the current plea bargain agreement?
Yes, Your Honor. And I'll just note for the record that Mr. Nisbet and I, who I originally reached this agreement with, anticipated that it would be a possibility that a revision such as you see now might occur at sentencing, depending on where we were at sentencing. And so I'll just say that Mr. Sanders has stepped into this agreement that was originally worked out with Mr. Nisbet, but Mr. Nisbet and I had anticipated that we might be at a place where we would propose an amended agreement, and that in fact has taken place. So we've been looking at this since the original plea in January of this year.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm going to show you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor, I do understand.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 10 years. There be a TAP evaluation. The state is requesting inpatient drug treatment at SATA followed by aftercare. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am, I'm fully aware of that. I understand, Your Honor.
All right. And with the change of the plea bargain agreement, are you still entering your plea of guilty?
Yes, Your Honor.
All right. And as previously stated, the court previously found there was sufficient evidence to find the defendant guilty, but deferred finding of guilt because the defendant has applied for deferred adjudication, and the court still finds that there's sufficient evidence of guilt. The only changes to the documents is the amended plea bargain agreement. Have both parties had a chance to review the PSI report? State?
Yes, Judge.
Defense?
Yes, Your Honor, as well as the TAP, and I've reviewed both of those documents with Mr. Pizzana, and we submitted a sentencing memorandum that I have sent to both the court and to the state, and we'd ask the court to consider what we have proposed in our sentencing memorandum as well.
All right. So any objections to the PSI report, State?
None.
Defense?
No, Your Honor.
All right, State, any objections to the court reviewing the defense's sentencing memorandum?
No, Your Honor.
All right, the court will review defense's sentencing memorandum. Just give me one moment, please. All right. Other than the documents that the court has reviewed, which is the PSI report along with the TAP evaluation and the sentencing memorandum from the defense, is there any other evidence, defense?
No, Your Honor, other than I'd like to argue this a little bit, and if Mr. Pizzana wanted to address the court, I'd give him the opportunity as well.
All right. State, any other evidence other than the PSI report and the defense's sentencing memorandum you'd like to present?
No, Judge, but I just wanted to bring it to the court's attention that there were exhibits and make sure you had those also that were attached to the memorandum.
Yes,
okay.
I do have those exhibits. All right, defense?
Yes, Your Honor. I wanted the court to know that Mr. Pizzana is present with the mother of his 3-week-old child, Priscilla Perez. She's present in the courtroom, in the back of the courtroom, and you also have her exhibit, the statement that she wrote. Mr. Pizzana is also here with Joe Gonzalez and Marissa Gonzalez. They are the grandparents to his 12-year-old daughter. She's present in the hallway, and his 3-week-old son is actually present out in the hallway. You have exhibits that state their position. before the
Shouldn't
court.
the children be in school?
Spring break. It's spring break, Your Honor, according to
Oh, okay. Brenda, you know how I am about children in school.
Yes, ma'am. And so I would, rather than just reiterate what's in the sentencing memorandum, number one, he's in full compliance, was in full compliance with the bond conditions, Your Honor. In the police reports, he's accepted complete responsibility. He consented to the search of his house, and he acknowledged possession of the materials that he's before the court on. He, you see the agreed forfeiture. It was a voluntary forfeiture on his part. A significant forfeiture has been accrued to the state of Texas in this case, not this case, but in the civil case. And that was by agreement, Your Honor. You also have the exhibits of the character witnesses.
All right, and Mr. McCray, with regards to the agreed final judgment that's attached, has that been signed by another judge or no?
It hadn't yet been signed, but that's awaiting a signature by a judge. I do have my signature and the state's signature on there. We don't anticipate any problem with the judge's signature on that.
Okay, and which judge is going to be signing that?
Judge, I'm not sure. I'm kind of letting the state present that to the court, and I think it's in the, you could see the style of the case. Let's see, it's in the.
I mean, it says 4-8, but that's
right.
just.
I think it just goes on a. Yes, ma'am. I think it goes on a civil presiding docket. Yes, my understanding. But we don't anticipate any problem there, and I'll put on the record that that is an agreed forfeiture, as you can see there.
And here's the number one thing, Mr. McCray. The number one thing that appears there's going to be some disagreement over is whether or not he should be an inpatient or outpatient.
Yes, ma'am.
So the question that the court wants to know is, if your client is drug tested today, what are the results going to be?
I'll let him say what the answer to that is, Judge.
If I'm drug
tested. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, yes, ma'am.
All right, you can lower your hand. Could you state your name for the record?
Victor Alexander Pisano.
All right, so let me explain something to you before I ask the question that I'm going to ask. When I ask people whether they're going to be positive or negative, it's really for me to determine or make a determination on where they are in their level of sobriety. Sometimes people will tell me they're going to be negative, and that's because they're praying to their higher power, and they're saying, if you let me be negative today, then I promise I won't use anymore. Sometimes the answer to that is no, you're going to be what you're going to be. So if you're drug tested today, which you will be drug tested today, what are the results going to be?
I believe that I will be negative. I say that because I stopped, if I may continue, I say that because I stopped smoking when we signed the plea bargain in January. And I know in my prior experience that it takes me about 60 days to be clean. So if I'm not clean, I know I have low levels, but I also know that the lab will reveal that. And that's the honest truth, man. I could very well be clean, but I could also have low levels. I know that it won't be high levels at all.
Okay.
I stopped smoking in January.
All right, defense, anything else?
Yes, Judge. He's got a 3-week-old child. He would like to keep working. He'd like to do this on an outpatient basis. I think Victor can do it. I think he's shown the court, and that's why we created our sentencing memorandum, so you could see how he's complied with all the pretrial conditions. I think he has the willpower to do this. I think he knows that he's facing 5 to 99 years of life if he violates conditions. He's in front of you, back in front of you if he violates conditions. He'd like to be able to look after his daughter. He'd like to be able to look after his son. He'd like to be able to continue working. So we'd ask the court on his behalf to consider the outpatient at this point. I think he's been honest with the court and with the law enforcement all the way up until now, and I see no reason to dispute what Victor is saying. And he's asked me to ask you if you would consider giving him the outpatient. And you can see from the TAP judge, he's highly motivated. So don't believe he's in denial. But this is an issue where he's sort of a chronic user up until the present circumstances. And he now has made some significant changes in his life, which I've outlined in the sentencing memorandum. And so we've just asked the court to do this on an outpatient basis.
What have you done to take care of your drug problem, Mr. Pisano?
So I've gotten in contact with people that I used to go to NA classes with. When I was 18, I went to NA classes, part of probation. But honestly, ma'am, if I could just be honest and blunt with you, the severity the severity of these charges and the severity of this case and everything that's put on me is more than enough for me to just step away from it. True, I did enjoy marijuana. I was a marijuana smoker, but now that I got these charges and I got things that are just, I can't deal with it, I could step away from it. I could definitely do it on an outpatient basis. I'm willing to do weekly drug testing. I'm willing to do anything and everything that you need me to do to prove to you that I can be a model probationer and that I could also succeed in this. I'm anxious and I'm hopeful, and I'm grateful for y'all giving me probation, and I'm hope that I could get the help that y'all want to give me, and I want to take advantage of that. I don't want to be a probationer that's up here trying to scam the system, trying to run game on you. I just want to get this past me. I want to do it the right way. I'm asking for an opportunity to prove myself to y'all, and I believe that I can and I will do that.
All right, Ms. Reyes, this is Victor Pazana, 2021 CR 7439. This is the court's rulings. Court will place you on 10 years deferred adjudication. There's a $1,500 fine to be probated. Taking consideration 2021 CR 7441, 2021 CR 7440. The patch, there's going to be a UA today by 1:30 p.m. Rebecca, if he is clean, then patch him. If he's not clean, then I want him tested for levels. Proof of employment within 15 days. There's to be no employment as a home health care provider with minors. 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination with the booster. Court is not requiring anyone to get the COVID vaccination, but if you do, 40 hours will be deducted. I'm going to want parenting classes with compadre y compadre. You must complete those parenting classes, and if you do, the remaining of your community service hours will be waived. I'm going to want field visits, random, 2 times per month. Regular reporting, in person, or by Zoom. So if you're not able to Zoom, you'll have to report in person. Do you understand?
I do, Your Honor.
And we will do NA or AA meetings 2 times per week. Rebecca, is there anything else that Mr. Pazana needs?
No, ma'am.
Mr. Pazana, is there anything else that you need from the court in order to be successful?
No, ma'am, I think you gave me a lot of things that are going to be very helpful to me, and I'm appreciative and I'm grateful.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, Your Honor, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor, I do.
All right, we can go off the record. Mr. Pazana, here's the thing. I'm trying you with outpatient treatment. If you see there's an issue or that you're going to use, you need to call your sponsor, or you need to contact probation and say, I'm thinking about using. What probation will do is probation will try to get you the help that you need. It's better than just losing your way and starting down that path. Do you understand?
Fully, yes, ma'am. Yes, Your Honor.
All right, so if you'll have a seat, probation will be with you shortly.
I'm sorry, Judge, on this one, you ordered outpatient. I didn't get that one.
No, he's just going to do AA, NA, or NA meetings. We're going to start with that.
I just wanted to clarify. Thank you.
No problem. He says that works for him, so we'll see. I'm sure. I say we'll see, Mr. Pazana, but I'm sure it's going to work excellent for you. That's really the key to sobriety, finding out what works for you and doing it.
Thank
All
you.
right, so if you'll have a seat, Mr. Paisano, probation is going to be with you shortly. Rebecca, we have one more probation matter.
My excuse, Your Honor.
Yes, but
Thank
your
you,
client
Judge.
needs to remain.
Yes, ma'am. Thank you, Judge. Thank you, Marcus.
All right, you're welcome. The court is calling 2021 CR 11077, State of Texas versus Matthew John Torres. Could I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Nathan Slimane.
And are you Mr. Torres?
Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No objections, Your Honor.
Mr. Torres, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that with your attorney? Did you understand it? Did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision or Deferred Adjudication. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
And did you electronically sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Mr. Slimane, have you received all the discovery in this case, and did you review it with your client?
I believe I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Torres, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
We waive it, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
On both counts?
Let me double check, Judge. Sorry about that.
No problem. The plea paperwork appears to be just count one and waiving count two.
And that's correct, Judge.
Any objections?
No objections, Your Honor.
Mr. Torres, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count one, you're charged with robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Torres, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, there's to be a $1,000 fine. State is proceeding on count one. State recommends deferred adjudication. There's to be restitution and no contact to Roberto Flores. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense is at the plea bargain agreement.
Your Honor.
State is at the plea bargain agreement.
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
Yes,
No
Your
motions, Your Honor.
Oh.
Next, I'm
There are
showing you
not, Your Honor.
outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 150 hours of community service restitution in CATS 1 and 2, and the MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contact? No contest.
No contest.
State any evidence to support the defendant's plea.
Yes, state offers States Exhibit 1 and its attachments.
Any objections?
No objections.
Mr. Torres, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We can proceed today, Your Honor.
All right, anything you wish to say on behalf of your client?
No, Your Honor.
All right, Mr. Torres, what is wrong with you? Why would you do such a thing?
Honestly, I ain't gonna lie to you. I did it because the reason that because I know that I know the person from a store that he works at. Well, he was drunk one night and he tried to grab my girlfriend, and my girlfriend was all like scared.
Okay, no, that none of this is true, what you're telling me. And let me just tell you why it's not true. I just read the police report. And what it is in the police report is that your girlfriend actually went to the store. They agreed to meet up. He didn't just mysteriously appear at a location where she was going to be. They agreed to meet up. He didn't mysteriously, he's not some CIA person who knew her phone number. She gave him her phone number. This all smells set up. So what it says in the police report, and I've read it, he stated she did not want to meet at the store, so he mentioned the park near his residence. He stated she agreed to meet with him. The victim went over to the park and texted her he was at the park. He stated she texted him back that she was walking over when he noticed two males looking at him at the park. He stated he knew something was not right, so he drove home, which was walking distance from his current location. When the victim exited his vehicle, the male suspect came up to him and asked him what he wanted with his girlfriend. The suspect hit him over the head with a rock several times. That's you. So this is not, he's harassing your girlfriend. This is them agreeing to meet up at a park. Are you employed?
So I'm self-employed.
Doing what? Besides hitting people over the head with rocks?
Rebar.
What does that even mean? Rebar, what is that?
I'm tying rebar.
Are you doing construction with rebar? What are you doing?
Yes, I'm tying rebar. Yeah, it's construction.
All right, do you have any children?
I have one daughter.
What is her age?
She's 3.
All right. And this girlfriend, the Sabrina Ibarra, is that the mother of your child?
No, ma'am.
All right. So your relationship with her is over while you're on this probation. Do you understand?
Yes, ma'am.
And who is Roberto Flores?
The dude that worked at the store that I know.
Okay. You need to not go by his store anymore. Do you understand?
Yes, ma'am.
And who is Daniel Boone? I'm sorry, that's the address. Just 1 second.
Okay.
You're going to say, hey, that's the guy from history. All right. The court is going to sentence you to a $1,000 fine that'll be probated. 5 years deferred adjudication. Restitution plus no contact with Roberto Flores. There's to be no contact with Sabrina Ibarra, Cats 1 and 2, the MRT, 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. There's going to be parenting classes with Compadre y Compadre. You must complete those parenting classes. If you do, the court will waive the remaining community service hours. There's going to be regular reporting by Zoom or in person. So if you can't report by Zoom, it'll need to be done in person.
Yes,
Bill
sir.
visits 2 times per month, random. Proof of employment within 15 days of release. No employment as a home health care provider with minors. And random UAs. Rebecca, is there anything else that Mr. Torres needs?
No, ma'am, that's it.
Mr. Torres, is there anything else that you need from the court in order to be successful?
No, Your Honor.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, Mr. Torres, we'll go off the record. Mr. Torres, here's the thing. 1, you were wrong for doing that. You need to learn from that. Number 2, many things could have went wrong that night. Sometimes people are prepared to protect themselves. Do you understand?
Yes, Your Honor.
All right, I'm going to send you to breakout room. And Ms. Reyes, I'm going to send him to breakout room number 4. And did you complete with Ms. Bagley or no?
I completed with Ms. Bagley, but I also need Mr. Paisana in that breakout room.
All right, to the courtroom, if you can go to breakout room number 4, and Mr. Slimane, you can go to number 4, or either you can be excused.
Thank you, Judge.
All right, anyone else ready?
I am, Judge.
All right, Charles Bach, yes. Your client is here.
He's here now, yes.
All right, so Mr. Farida, I'm going to send you to breakout room number 5 to speak to your attorney.
Thank you. Thank you, Judge.
You're welcome. Mr. Mamori, you're back.
Yes, Judge. Judge, I need to have on Nicholas Courtney, Judge, I'll be conferring with 88's Brittany Sparks on that, Judge. If I get a reset on that, please. I've talked to Mr. Courtney, and I think the issues that I had, or the questions I had, concerns I had, have been resolved.
Okay.
And then also,
yes.
And on Virginia Ruiz, Judge, I need to confer with her about a matter that has come up that I was just informed about.
Okay. All right, Ms. Ferguson, on Mr. Courtney, can I have a 30-day reset, please? All right, we're going to come back on April 26th.
April 26th. Thank you, Judge. And Judge, I think we will have this issue resolved before then.
All right, just let Ms. Ferguson know and we'll place it back on the docket.
Okay. And then on Virginia Ruiz, Judge, may I confer with her and be excused from there? Is that possible?
You'll need to make sure that she comes back to the main room.
Yes, Judge.
All right, I'll send you to breakout room number 2.
Thank you for your time, Judge.
Oh, you're welcome. And Ms. Ruiz, if you can go to number 2. And Ms. Ferguson, Mr. Courtney is excused. And everyone, just give me a moment, please. Yes, Mr. Ostersdorf.
Yes, Judge. I'm sorry. I'm like a ping pong ball here, still going on other 2 courts. I guess Mr. Sanders, I got him a while ago, but he had to leave to do.
All right, I sent you to breakout room number 6.
Okay.
Charles Bach.
Yes, Your Honor.
Hi. So what is happening with your client?
I conferred earlier with one of the prosecutors, Joe Ray specifically. He informed me that there is a new case that hasn't yet been filed that might involve my client, and he wanted to look into that and then kind of give me the lowdown on the new case, and then we could reach a decision.
Okay.
Joe Ray, is that accurate?
Yes, it is.
All right, Ms. Ferguson, can I have a regular reset on Mr. Parita, please? All right, we're going to come back on April 26th.
Okay. I'm here that day. Perfect.
If you have nothing else with us, you are excused.
Thank you, man. Okay. Y'all, everybody have a good day.
Thank you. You too. All right, Norma, Mr. Parita, L2 can go back. And Mr. Alcantar, who are you here for?
Good morning, Judge. I'm here with Mr. Isaiah Ibarra regarding a GPS matter.
Okay, I don't see that person on the screen.
He's right here in my office, ma'am. He does not have a Zoom at his residence.
Okay, let me find him on the docket. I'm sorry about the wait. I didn't know this is what you were here for. Just one moment. All right, so this is the court's concern with this case, is that you're asking that he not be on GPS because of financial issues. Is that correct?
Yes, Judge.
All right, so the problem though, is that he is on a case that was an aggravated robbery that was reduced to a robbery, and we still don't have any of the MIC mouth and everything else that needs to be done. Is that correct?
Yes, Judge. He completed the GDRF program September of 2021. He is currently active with the Center for Healthcare Service Genesis program, and he's in the Mental Health Initiative program with the probation office.
All right, so how can I be assured, like what type of supervision is gonna happen instead of him being on GPS?
Currently, he's reporting to the probation office twice a month. He's drug testing monthly, and he's active with the center, the case manager and provider.
And how often does the case manager contact probation? Because I see here where it says that he's missed some appointments. Is there a reason for the missed appointments?
Yes, ma'am. He has not been perfect with his attendance due to being on the bus, financial issues. So I think a couple of times he forgot his appointment. So he's one that we have to make sure he has his calendar with him every month. But in my opinion, Mr. Ibarra has a positive attitude. He's always been very upfront, no drug and alcohol use. At this time, he's still working on gaining his ID and social security card, and he cannot fulfill the obligation, the condition of the GPS at this time. I was hoping that we could put the GPS on hold until he's able to get his ID and employment.
So is he seeking employment or SSI?
He has not officially applied for the SSI. He's working on getting his ID and social security card to try and work.
All right, I'll hold the GPS in abeyance. Mr. Ibarra, where are you?
Let's switch. Let's see. Okay, go ahead, look into the camera.
Mr. Ibarra, you need to make sure that you stay in contact with probation and stay in contact with your case manager, okay?
Yes, ma'am.
All right, do you need anything else from the court to be successful?
No, ma'am.
All right, thank you.
Thank you, Judge.
You're welcome. All right, I'll hold it in abeyance.
Thank you, Judge.
All right, you're welcome. Thank you for coming in and thank you for your patience.
May I be excused, Judge?
Yes.
Thank you, ma'am.
Norma, this is Jim Ultersdorf. Can you hear me, Norma?
Yes, sir.
Oh, I'm going to go do a plea and I'm going to come back. We're still negotiating on Jasmine, Colorado, okay?
All right, Mr. Osterdorf, on Jasmine, Colorado, have you had a chance to speak with Ms. Colorado?
I have, and she would like to have a chance to talk to the DA and myself, but I need to go do a plea because I have a client who's on her lunch hour in County Court 4.
All right, so we're going to come back on your case at 2.
Okay, 2 o'clock. Thank you. Can you
You're
tell
welcome.
Mr. Can you tell Mr. Marcus Sanders
He's
to
aware.
Okay, thank you.
You're welcome. All right, Ms. Colorado, we're going to come back at 2 p.m.
2 p.m.
You're welcome.
All right, thank you, Miss.
All right, as soon as I swear your client in, we'll take up that matter. And if the clerk, if you can go to breakout room number 3, please. And if counsels, you'll go back to breakout room number 3 to make sure all the paperwork is done. All right, Ms. Ferguson, Ms. Ruiz can go back.
Yes, ma'am. I'm sorry, Your Honor. May I be able to say something?
Yes.
I had just signed some papers saying that I had a warrant on the other side, but I've been in jail since since February 1st, and my family had.
Just one moment. You'll need to speak to your attorney.
Is he still on here, or because he had told me that you had made a bond for me on my MTR so I could get out, but then they had said that I have a warrant because I was in jail and I wasn't let out to report.
You'll need to speak to your attorney.
Okay, Your Honor. Thank you very much.
All right, thank you. You're welcome. Norma, if you can let them know Ms. Ruiz needs to go back, and if you can contact Mr. Mamori.
Thank you very much, Your Honor. Have a good day.
Thank you. You too.
Yes, ma'am.
Judge, I just sent you a chat.
All right, thank you. Norma, just have Ms. Ruiz and Mr. Mamori come back at 2 p.m. because I think she needs some more information explained to her by him. Michelle Garzas, we're going to see you back at 2 p.m.
Okay. Yes, ma'am.
You're welcome. Mr. Gonzalez, we're going to see you back at 2 p.m. All right, Ms. Valenzuela, has the clerk informed you that all the paperwork is complete?
We are just missing, all the paperwork is complete. She has sworn to it. I just got the discovery acknowledgements. We were gonna just sign those real fast, Jenna.
All right, thank you. Thank you.
Judge, I send you a chat.
All right, thank you. What is he trying?
I don't know, Judge.
Okay. All right, Mr. Martinez, we're recalling your case for 2. All right. All right, is everyone ready? Who's the prosecutor on Cheryl Martinez?
Joe Ray, Judge.
All right, and Rebecca, this is no application.
Thank you, Judge.
You're welcome. All right, the court is calling 2022 CR 1265, 2022 CR 1653, 2022 CR 1743, State of Texas versus Cheryl Marie Martinez. Can I have parties announced for the record for the state?
Joe Ray Garcia.
For the defense?
Keith Key. I believe there's another attorney, Catherine.
And I'm on 2022 CR 1653.
All right, and each of the cause numbers we're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Are you Cheryl Martinez?
Yes, ma'am.
And each of the cause numbers, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review those documents with your attorneys? Did you understand it? And did you electronically sign it?
Yes, ma'am.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily consented to appear by video. Counsel, in each of the cause numbers, the court is showing you what's entitled Discovery Acknowledgement. And each of these cause numbers, have you received all the discovery and did you review that discovery with your client?
Yes, ma'am.
Yes, Your Honor.
And in each of the cause numbers, the court will find that the state is in compliance with discovery. Ms. Martinez, in each of the cause numbers, the court is showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
Counsel, in each of the cause numbers, do you waive the reading of the indictment?
Yes, ma'am.
Yes, Your Honor.
State, in each of the cause numbers, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Martinez, in each of the cause numbers, I'm showing you what's entitled Court Admonishments. Did you review those documents with your attorney? Did you understand them? Did you electronically sign them in all the appropriate places?
Yes, ma'am.
In each of the cause numbers, you're charged with theft under $2,500 enhanced. That is a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in each one of these cause numbers?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses to the offense?
Yes, Your Honor.
We discussed that, yes, Your Honor.
In each of the cause numbers, do you believe your client has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Yes, Your Honor.
In each of the cause numbers, do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Yes, Your Honor.
Ms. Martinez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
In each of the cause numbers, has anyone promised you anything other than the plea bargain agreement to get you to enter the plea?
No, Your Honor.
In each of the cause numbers, are you satisfied with the way you've been represented?
Yes, Your Honor.
In each of the cause numbers, are you a U.S. citizen?
Yes, Your Honor.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived her right to jury trial. In each of the cause numbers, I'm showing you the plea bargain page. Did you review those pages with your attorney? Did you understand them?
Yes, Your Honor.
And each of the cause numbers, are the cases running concurrent with each other, counsel?
Yes, Your Honor.
Yes, Your Honor.
Right. And each of the cause numbers, the cases are running concurrently. In each of the cause numbers, the state is requesting that your punishment be assessed at 15 months in the state jail facility. There's a $1,000 fine. The state will take in consideration the following cause numbers: 2020 CR 1654, 2022 CR 1744, NIMAG number 639746, 639744. The following CM numbers: 93845, 93844, 909, and that number's been cut off. What is the number?
39, Your Honor.
And the final cause number is CM 90939. Did you understand that to be the plea bargain agreement, Ms. Martinez?
Yes, Your Honor.
Defense counsels, is that the plea bargain agreement?
Yes, Your Honor.
I believe it is, Judge.
All right, state, is that the plea bargain agreement?
It is, Your Honor.
In each of the cause numbers, I'm going to show you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
No, ma'am.
Then to the offense as charged in 2022 CR 1265, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
In cause number 2022 CR 1653, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
And in cause number 2022 CR 1743, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's no contest, please.
State offers State's Exhibit 1 and its attachments in each of the cause number.
Any objections?
No objection.
No, ma'am. No objections.
Ms. Martinez, in each of the cause numbers, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you electronically sign them in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Then each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. In each of the cause numbers, the court will accept into evidence State's Exhibits 1 and attachments and review the same. can I see counsels in breakout room number 1, please? Here, we're back on the record. The court has reviewed State's Exhibits 1 and attachments in each of the cause numbers. In each of the cause numbers, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each of the cause numbers. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
No, ma'am.
Nothing for the honor.
Then in cause number 2022 CR 1265. I'm sorry, Ms. Martinez, what plea did you enter in each of the causes, please?
Contest, Your Honor.
Okay, thank you. It's just that I did not write that on the docketing sheet. In cause number 2022 CR 1265, as previously stated, the court is finding you guilty. The court will sentence you to 15 months in the state jail facility, give you credit for any time served. There's a $1,000 fine, time and money will run concurrent. Thank you. Take in consideration 2022 CR 1654, 2022 CR 1744, NIGHTMAD number 639746, 639744, CM numbers 93845, 93844, 90939. This will run concurrent with 2022 CR 1653 and 2022 CR 1743.
Your Honor, in regards to the credit for the time, Ms. Martinez was in custody in April and May of 2021, and that's not reflected in any of the cases that she is pleading on today, and we would ask for that time to be also granted to her. It's one of the cases.
These cases were not pending at that time, then she's not receiving credit for that. So were these cases pending at that time?
I believe they.
I'm not sure.
Lucas said he would look into it, but we had to have your okay if.
I'm not going to give her credit if these cases were not pending at the time.
So you would give her credit for any cases that were pending?
If she was in custody.
Okay. All right, Your Honor. Thank you.
You're welcome. And cause number 2022 CR 1653. As previously stated, the court is finding you guilty. Court has sentenced you to 15 months in the state jail facility. Your credit for any time served, $1,000 fine. Time and money will run concurrent. This will run concurrent with 2022 CR 1743, and 2022 CR 1265. And cause number 2022 CR 1743, as previously stated, court is finding you guilty, sentence you to 15 months in the state jail facility. Credit for any time served. There's a $1,000 fine. Time and money will run concurrent. This will run concurrent with 2020 CR 1265, 2022 CR 1653. Take in consideration 2022 CR 1654, 2022 CR 1744, NIMAG numbers 639746, 639744, CM numbers 93845, 93844, 90939. In each of the cause numbers, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those documents with your attorney? Did you understand them, and did you electronically sign them?
Yes, Your Honor.
In each of the cause numbers, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
In each of the cause numbers, because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, then you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, Ms. Martinez, here's the thing. You need to stop stealing.
Yes, Your Honor. I understand that.
I mean, if you were on probation, they would give you a theft course. Here's my theft course. Don't take what doesn't belong to you. Otherwise, yes, you're going to wake up and find yourself spending the rest of your life in prison or in and out of prison because you decided that you don't want to work for what you want. You want to get what you want for free.
Yeah, yes, Your Honor. I've always worked. I understand that. I fell.
Just steal.
Yes.
No, it's not. This is the thing. Don't come with me with saying you've always worked and this is like the first time you're here for theft enhancements.
Right. No, it's not the first time. It's been about 4 years. But other than that, I've worked since I was 13 years old. I understand that, Your Honor. And I don't plan on doing any of this again.
Yeah. And don't make excuses for it because there are other people who fall on hard times. They don't steal.
Yes, Your Honor.
All right. Good luck to you.
Thank you.
You're welcome.
Yeah, I have a question.
Yes.
There was some conversation about credit for time served, and you said that she would get credit for the cases that are being charged. I just have a question about the cases where she's getting that are being taken into consideration. If she served time on those cases, will she get credit for that?
Yes, if she was in custody, whatever cases she were in custody for, she'll receive credit for.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
All right, thank you. You may be excused.
Thank you.
Have a good day, Your Honor.
Thank you. You too. Bye-bye.
Judge, I had another case in this court.
All right, that'll be back at 2 p.m. We're going to take our lunch break.